Welcome to Higher Results, where business, workforce, and talent intersect. Hello, I'm Melodie Reagan. I'm the CEO of I Workforce, and I am your host. On Higher Results, we cover all things HR. That's from recruiting and hiring to performance management, all the way through to retirement and even termination. We're here to give you tips and tools that help you achieve that top performing workforce and that incredibly successful career. We air every Tuesday at 3 p.m. Mountain Time. Please join us. You can find us on Facebook at Innovation Pavilion, and you can also find us on Facebook at Higher Results. And if you miss an episode, don't worry. You can go back and find those episodes on IPTV, and you can also find them on I Workforce /Higher Results. Now, one of the things I'm going to tell you about I Workforce, you can also get our episodes in podcasts. So if you want to download and listen to them, please find us there. And one other thing, if you have any questions or any topics you want us to cover, we're here to help you in any way. Just let us know online. And today we have our favorite attorneys back with us today, and I'm going to introduce them in a moment. We're here to talk about the lawsuits that business owners never see coming. Now, I'm going to share a couple of things with you before we get started. Are you aware that are you ready for this? Over 1 million cases are filed in the U.S. state court each and every year. It's crazy how many cases there are. And one of the things with HR is business leaders and owners, we are responsible for HR compliance for our workforce. It is something that comes with being a business owner. And guess what? Those laws and regulations exist to help us run better operations. So they have purpose. It's just that sometimes in the complexity, it can be a little difficult to track them and make sure that we are compliant with all of them. Well, we're going to dig into a couple of them today that can kind of sneak up on you and they can get you. And I'm going to share another thing. As business owners, did you know that 75% of us are actually incredibly worried about being sued for something? It's something that is a concern for us, for our businesses. And according to, I love this, Faces of Lawsuit Abuse, a firm that makes $1 million in annual revenues will on average spend $20,000 in legal fees. Well, guess what? Better to spend that $20,000 than to all of a sudden be taken out of business because of a frivolous lawsuit or a lawsuit because you made a simple, minor, unintended mistake. So with that, coming to our business owner's attorney, I'm thrilled to tell you that Justin Vaughn is with us today. Welcome again to the show, Justin.
Thank you, Melodie. Great to see you.
Great to see you. Well, let's start off. You know what? I know you. I would love it if you would start off and just share a little bit with our audience about you and your firm.
Sure. I've been an attorney for 25 years, had my own firm for 17 of those years. And our primary focus is representing business owners, from business creation to development, most importantly to business protections, through the sales process and succession planning and estate planning for business owners. The goal being to help the owners be successful.
Yeah.
Particularly, we want to see people who work hard and with integrity, doing what they're doing, fueling our economy, and we want to help them succeed in that without the types of threats and problems that you've described.
By the way, I love, you're the one that takes care of that 75% of us having as a fear factor. You keep us out of those situations.
We try our best.
Well, you know what? I actually have to tell you, I think that this is a show that could go on and on and on, but because there's so much for us to cover. And I'm going to start with the very first topic that I have, wage claims. We pay our employees. We also have contractors, right? So let's start off with what are the laws and regulations around wages? And I want to dig in a little bit to minimum wage and overtime pay as well.
Sure. And that's one of the things that is critically important in having, whether it's outsource or in-source, in-house HR options, you want to make sure that you're monitoring. And it can vary from state to state. Obviously, there are federal minimum wage laws, there are overtime laws. Those change from time to time. We recently had some anticipated changes and it reverted. But the key thing in terms of wage issues with employees and what the Supreme Court has recognized as one of the fastest growing areas of lawsuits against business owners is really twofold. One, when an employer makes a mistake in terms of their wage calculations. So they need to get sound advice under current law, under the state they're in for that. The second major issue is work that is done off the clock. And employers need to make sure that that's not happening. So, yeah, absolutely. For example, you have an office manager who delivers the mail to the post office or takes FedEx during lunch. Now, that is something that they perhaps clock out for, but some amount of time down the road, whether it's months or years, they then can come forward and say, that was still work time. Mm-hmm. And I did not get paid for that. And then that may cross them into overtime. It may encroach into penalties and other issues. And judges overwhelmingly are taking the side of an employee. So it's important to make sure you have policies and procedures or an employee manual that expressly prohibits any work that is done off the clock. It is critically important that you enforce those policies, and we are seeing just a huge explosion of wage claims in that category.
Well, I want to ask about this one because it's exactly, what's the difference between an exempt and a non-exempt employee? And do these laws have differences based on the type of employee that you have?
Well, and again, you're going back to some of those issues that are shifting from time to time. But an exempt employee is an employee who is in a particular profession, in a particular position where they are exempt from the minimum wage requirements. That can vary from business to business. It can even vary from position to position within a business. Mm-hmm. And those are critically important to look closely at. It is just important for any business owner to be well advised, to know exactly what they're looking at and what their expectations are for any given professional employee.
By the way, along those lines, I can tell you, for the most part, I think businesses do a pretty good job of separating between exempt and non-exempt. What does happen, however, is for the employees that really are hourly, a lot of businesses get it wrong. And that's where there are times they'll put somebody that is exempt that actually is not. And then we have to go in and say, no, you need to adjust it, because this is actually one of the things that you're talking about. It's retrospective. Mm-hmm. If I have it wrong, I can't say, well, they were classed this way when it happened. In actuality, it's what they should have been, and that's what my liability is.
Exactly.
So getting it right matters, right?
Exactly. And it really is a case-by-case situation.
So in terms of minimum wage, overtime happens. I just want to make sure everybody knows this. When do I go to overtime? What are the terms for when I have to be sensitive to going to overtime?
For the amount of time that you go into overtime, well, and again, this is your department.
Yeah,
I call you when I have those questions.
It totally is.
But for the overtime, and again, it's different under certain circumstances because there are timing restrictions. The trucking industry, for example, has certain complex timing restrictions.
By the way, that's exactly. Good job.
Oh, no, as a general rule, you have the parameters and you have the full work week. But again, very important to ask for your specific situation in your business.
By the way, it really does matter, and you truly need to pay attention to it. It's typically where you have an 8-hour day, you have a 40-hour week. Right. That's America. Right. However, it does vary based on roles, responsibilities, and it's exactly what you're saying as far as somebody who's a trucker, et cetera. All right, well, let's keep going. We have more amazing topics. I know we're going to run out of time today, so we're going to have to come back and do another one. Let's talk about, I'm just going to jump in, sexual harassment. And, we're going to talk about what are some of the common things that you can run into that are going to hit you. So let's talk about what are the laws and regulations around sexual harassment.
And well, fundamentally don't.
Yeah.
That's the important part. The sexual harassment laws under Title VII of the Civil Rights Act prohibit any type of discriminatory conduct against somebody based on gender, which has been interpreted as also applying to certainly sexual situations, as well as now the EEOC is interpreting that as applying to sexual orientation and transgender issues.
And so that everybody knows, EEOC, equal opportunity. So let's just make equal employment opportunity. So let's just make sure everybody knows what EEO is.
And that's the commission that enforces those terms, along with the Attorney General's offices in each state. So you don't want to run afoul of government agencies like that. It can be expensive. It then causes the 20,000 that you were saying per million in your business. But the most important thing in terms of sexual harassment, it can take a couple of different forms. It can take a hostile work environment, which has to truly be a hostile work environment. The judges aren't necessarily open to small little moments. But if there is something that is construed by somebody to create a situation that is reasonably offensive to a reasonable person, then judges will look at that, administrative agencies will look at that and say, okay, you've created a hostile work environment. Certainly a quid pro quo, if you do sexual favors, then I will give you this promotion. Those types of things clearly violate Title VII and constitute sexual harassment. But there are key things that an employer can do, because you can't watch every manager, every co-employee, every minute of the day.
You can't.
And even if the employer is the best, most likely to be sainted person on earth, you still need to protect yourself against those types of claims. So one of the things to do is to have what's called employment practices liability coverage, or EPL coverage as part of your business policy. Right. That will pay not only if somebody does something wrong, but it will pay an attorney if you have an employee who just makes up a claim. So that type of coverage, I think, is critically important. Aside from that, what an employer can do is, first of all, have a policy that prohibits and gives an opportunity to report any type of sexual harassment. Teach that policy. Make sure that you have orientation, that you have conveyed to all your managers, all your staff people, anybody in the business, exactly how those situations are to be handled, and how to avoid those situations and what the policy is. And then third and most important, enforce that policy. If somebody comes forward with a claim, and you want to have at least two avenues that they can report to, but if somebody comes forward and reports it, take it seriously. Some of the absolute worst outcomes in a case, in litigation that's filed, occur when an employer says, well, nobody will believe this person. This person lacks credibility. Nobody's going to believe their story. Nobody's going to believe what they say.
Can't do that.
But guess who will?
That's right.
It'll be the judge.
That's right.
The judge will listen to them, and they don't care about their background. They don't care how dishonest they've been in the past. They don't care about other things. In fact, there are rules that prohibit the judge from even considering that. The judge will take it seriously. And once it goes to court and you haven't followed your policies and procedures, you haven't brought people in, you haven't done a full investigation, it will not go well. So it is critically important to make sure you have those policies and procedures and take every claim seriously.
By the way, I just want to highlight a couple of things that Justin just said. I want to make sure that everybody knows, because this is something our clients get a little confused with. We tend to think sexual harassment is about the quid pro quo, and it's about how we're talking to each other and showing up. But it really includes, what's really important, it does include inclusion. It's how you treat every single worker with EEO, and it also does include where anger coming into the workplace, a hostile work environment, and there are dynamics where sometimes people are talking politics and they can get into a serious fight over politics, and it can be perceived negatively.
It can be just telling inappropriate jokes.
Exactly.
And sometimes people blur the line on what's inappropriate and what's appropriate. It can be making advances. It can be just making comments that are offensive to somebody of the other gender.
Exactly.
It can be any number of things. And we've talked before about the mom test.
I love the mom test.
And thank you for that. The mom test says, if your mom was standing next to you, would you say that? But I would like to take that a step further today.
Fantastic.
The question, I think, should also be posed, if that other person's mom was standing in front of you, would you make that comment? Would you make that joke? Would you say what you were about to say?
That's a fantastic one.
And if the answer is no, you wouldn't say that, then you're probably better off just not saying it at all.
So by the way, I do want to say that there's one other thing for you to consider about this. It's really important. We've been doing a lot of sexual harassment training for a variety of different firms, and it's exactly what you said about policies. One of the things that I've observed with firms that are out talking to to their workers and telling them what they should and shouldn't do, here's something about the environment. You need to empower everybody, and you need to encourage all of your workers to speak up for themselves. So, for example, it's something that maybe somebody is saying that I'm not comfortable with. I need to tell them I'm not comfortable. So it's not just a one-sided. Relationships happen because people communicate with each other. It's okay for you to say to a coworker, you know what, I don't want to discuss politics with you. It's okay. We're here to do work. I like you as a person. Let's not have that as part of our conversation. But it's important for both sides to have that conversation.
Absolutely. And if you want to avoid litigation over those issues, you want a culture that encourages people to be okay with defining those boundaries.
That's right.
And to be okay with speaking up if they feel that those boundaries are crossed. To treat it, as the opportunity presents itself, to treat it by saying, I'm not comfortable with that first. But if it continues, to have a remedy, to have somebody they can turn to. And
for those, part of the reason, I love that you said it's like having two avenues. You can go to HR or have somebody's boss's boss, because if you're having an issue with your own boss, you need to at least have two avenues for reporting. It's okay. And if you're not comfortable saying something, empower somebody within the organization to create those boundaries for you. So, and the regulatory agencies will like you a lot more if you have those in your employee manuals and your policies and procedures. Absolutely. Because that's what they look for. By the way, and that's one of the things we go through employee manuals with a fine-tooth comb to make sure they have it and that they don't have policies that are in conflict, which is, we're going to go to the next one today. Here's one that's nice and confusing. Employee, independent contractor. We know W-2, we know 1099. All right, so how do we get this one so mixed up? What's the difference? I'll tell you, administrative law judges are cracking down on this. The IRS is cracking down on this. They came out in the last 2 years and said, we are not going to accept the misclassification. And part of it came about because of the types of benefits that employees are increasingly getting under the development of federal and state laws. So employers have tried to take, whether it's a group or an individual, have tried to take employees and recategorize them as independent contractors. And then when they get in trouble with an administrative law judge, they say, well, wait a minute, that employee agreed to it. They signed off on it. They accepted the 1099s. They signed the tax forms. None of that matters at all. The question is, what is the true substance of the relationship, and do you qualify as an independent contractor? And those laws also somewhat vary from state to state. The federal, the IRS and the federal government primarily look at the extent of control. Colorado has a specific state statute on the issue. They have the key factors to look at, and two important things. One, the statute says that if you don't have a contract in writing, it is presumed to be an employee, not an independent contractor. Okay, did you hear that? If you do not have a signed contract for a contractor, it is presumed that it is a W-2 relationship and you should be paying taxes. Right. And secondly, when they list out the key factors, those are factors that create the presumption that they're an employee rather than an independent contractor. I have yet to have, and I've done hundreds of independent contractor agreements, I have yet to have anybody come to my office with an independent contractor agreement that they already had that complies with Colorado law. Yeah, I have yet to see one. You want to make sure get it reviewed by an attorney. Get it reviewed. You absolutely want to make sure that it complies with those factors. Yeah. And the key components being you can't exercise control over that person. Provide them the materials of their work, pay them as an individual, define their work hours. You can't take your receptionist and say, okay, now you're going to be an independent contractor. When you tell them where to work, how to work, what to do, you provide the computer that they sit at, you provide the desk they work at. That, in the context, that's never going to be anything other than an employee. And again, in certain industries, there are exceptions. So, for example, in real estate, you can be a real estate broker or agent under Colorado law and still be an independent contractor. And that's a unique carve-out under the statutes. But for the most part, the question is, what kind of control do you assert? Do they look like an employee? Do you control them like an employee? Tell them what to do, set their work hours, etc. And that's what you look for. If you're going to call somebody an independent contractor, they need to really be an independent contractor. Otherwise, you're going to get hit with penalties, unemployment claims, workers' comp claims, and it never turns out well. So I want to delve into this a little bit because I do see where people get confused. Now, when you're saying setting work hours, if you're telling somebody that you have to be at the office every day from 12 to 5. I'm setting work hours for you. If I have to train you within your discipline, there's a difference between training. Like if I bring in a contractor, I may have to let me show you the way we do certain things for the project I'm fixing to give you is a very different demeanor than here, I'm going to train you into this role and I'm going to continue investing in your career and I'm going to pay for you to go to college. It's also very different with contractors that you're deploying that you're in a situation, you say, hey, we got a meeting at 8 a.m. tomorrow. Need you to be there. If I need you to be at a meeting to get something done, that's not me exerting control over you. And what I would recommend is with the show, you're going to have a couple of links that you should just go take a peek at. And you should go through and look at it. And if you have any confusion, is this really somebody who's a contractor, or am I exerting more control over that individual? Am I controlling what they're doing, their hours, giving them all their tools? Like, don't go and give computers to your contractors. Don't give them the tools of the trade unless there's a difference. If I'm sending you out on a field for a day and you're in my mine and you're working with all of my equipment, that's a different thing for one day than me giving you a tool that you use repetitively throughout the entire course for 5 days a week, 8 to 5.
And it's the totality of the circumstances. It's not any one factor. There is not one factor that's going to define one category or the other. It's the overview of all of those factors. It's the extent of control primarily, but all of those come into play. And if you look at it and say, I don't meet any of those factors for an independent contractor, then the answer is pretty clear.
By the way, I'm going to give you one other one that I've run into with clients. It's really important. You may have an independent contractor and they don't want to quit being an independent contractor just because they don't want to quit being an independent. If they don't want to stop being that independent contractor, if they're doing work of a W-2, you need to make them a W-2. It's not about what they want. It's about the legality of the situation.
Everybody, when they're getting along really well, everybody seems to be just fine. You need to plan, and the way you really protect your business is to plan for those times that you're not getting along well. If that person were let go, would they hesitate to file for unemployment benefits and to file potentially a workers' comp claim to do all those things? That's how you have to protect yourself. Yeah.
By the way, that is such a great way. It's one of those things that I love the way you think. I always forget with an attorney, it's almost like an auditor. You have to think of what the exception is. And you do a fantastic job of that. And on top of it, Justin, you're just so nice. It's like you're so nice when you think about those things.
I see the worst case scenarios, so I know these things happen, but I also want to turn it for the best. And I always want to give people hope. There are solutions, but I'd rather be preventative rather than curative.
I think that's a talent. Sometimes I'm a little gullible. I'm like, I want to believe in that person that they're going to do this. All right. Well, I think we only have time for one more. So I'm going to go with... we have a couple more topics, but hey, we're just going to have to do this again. The one that I want to go with, and I do think this was important because guess what? I've had this happen for me. It's called the business owner's divorce. You own a business, and what should you be preparing for in the event that you have a divorce? And it's a really important one. It's like for me to have a partner in a business. I don't want to be in business with their spouse if something happens, and it's not that it's a one-to-one. So what are some of the things we need to consider for the business owner that could be going through a divorce?
Well, and there are two types of divorces business owners go through. Well, one is the divorce from their spouse, and the other is the divorce from their business
that's
partner.
Right.
And remarkably, those two have quite a few similarities.
I've done both.
Have you? I have done both as well.
And they both ended positively.
Good. The divorce of a spouse or a partner's divorce of a spouse raises a number of issues. Like you said, you don't really want that person's spouse as your business partner and owning part of the business.
I don't want to get caught up in their divorce either.
You do not. And to have that person as potentially a voting member of an LLC or a C Corp, whatever the case may be, just not appealing. And to continue that drama because they both own a piece of it. It's not what you would want. One of the things that I strongly encourage is to have a buy-sell agreement or a shareholders agreement, partnership agreement, whatever category you put it in, but to have text in some form signed by the partners that agree that if a divorce were to occur, they will give their spouse everything else that they own as assets before they allow them to take a part of the business.
Oh,
and that's a commitment that the partners make to each other. It's pretty extreme, but it solves most situations. Now, for other situations where that is not adequate, where the value of the business is so much, and on average, for business owners, most of their net worth is the business. So
that's very true.
If the other assets are not adequate, you want to also have language that says that in the event the spouse is awarded anything in a divorce that has any types of rights or ownership in the business, that those can be redeemed by the business. And the best thing to do is have spouses sign off on that as well. And then the business can redeem those interests. It means money is paid. It means you want to have some type of fund set up, some type of reserves that enable you to pay that, or define it over time. The specifics can be worked out, but the important part is that language appears so that the spouse can never be a business owner.
Fantastic. And is there anything, because I truly was thinking about the business owners divorces. Is there any comment, or actually, you know what, the partnership agreements? Mm-hmm. I actually think we should come back and add that to one of our other hidden, because there's a couple of things that I see people who do regularly incorrectly with their partnership agreements.
And the key is to have that buy-sell language. If somebody wants to retire, if somebody becomes disabled, if somebody, God forbid, were to pass, you want buy-sell language that defines exactly what you're going to do. And there are a number of different approaches to that, and I would love to come back and talk more about that.
Fantastic. And you know what else that makes me think of is we talk about this, believe it or not, you have insurance. It's available for all of this. There are ways that you can actually give yourself a safety net for these things, and you don't think about it, or you can take advantage, like in your balance, to help you with wage claims. You can consider PEOs, outsourcing, making sure that you're paying people correctly, have somebody else that they're experts in it do your payroll. The other thing that I'm going to say is as you come through with your employees versus contractors, if you think somebody is behaving a little more like an employee, make them one. Don't take the risk. It's not worth it. Because the other side of that, it's interesting from my perspective, each state and each government, that's one that governments are going after more because people are hiding the money. Right. And it's like they're looking for good reporting. And these are simple things. They cost you a little on the front end that go a long way. That's something that's really important to me. Given our businesses, the two that I have, it's really important for me to do good business. It's got to be clean and do good business. But, these are things that they can happen not because they're intended. It's just they're complex, they're hard to understand, and that's when sometimes you need to go to the business owner's attorney and say, hey, can you look at this for me or help me with it?
And have solid, reliable people advising you.
Exactly.
Not just an attorney, but get solid HR advice,
good
get solid
HR,
accounting advice, and have professionals who know how to communicate to make sure that the whole picture is being protected.
Exactly.
That's how businesses develop.
Well done. That's excellent. Justin, as always, you are fantastic. Thank you so much for being here with us today. And I want to say that to our audience as well. Thank you so much for being here with us today. We hope that you come back and join us again next Tuesday at 3 p.m. Mountain Time. And if you miss an episode, don't forget you can see it online at IPTV. And you can also see it at eye2eyeworkforce.com. Just click on the menu, and we also have podcasts. So until then, we're wishing you higher results.